hearing the matter on Secretary of State for Health and another, and Servier Laboratories Limited and others. Part 1.
My lords, you should have a short handout in front of you. I've given it to my learned friend. Now, what I thought I would do to help speed up my submissions today, and because I don't really want to have to go to all of these cases, would be to set out the relevant extracts or references on the page. And while I was at it, I thought, well, I might as well give you the references from yesterday as well. So that's all it is, and I would then pick up my submissions at, on page 3 of the handout. We're at the section which is headed Older Case Law.
Thank you.
This is where you got to
That's
effectively yesterday.
Exactly, that's where I've got to. So I thought I might as well give you all of the references, but we won't go over them again today. You'll be very pleased to know. Newman and Zachary, we were told by my learned friend shortly before the hearing that he's no longer placing any reliance on that, so I don't need to take you to that case. I know we all got excited about it yesterday.
Very excited.
Allen and Flood, I did touch on this yesterday, and I don't think we need to go to it. The point about, the short point about Allen and Flood was that it was cited for the actionability requirement by Lord Hoffman in OBG. But in any event, on the facts of the case, that was a case where there was an interference with the third party's dealings with the claimant, because it was threats to employers to cause them to discharge shipwrights who'd been engaged to work on a particular ship because some of the other employees didn't want them to be hired. Quinn and Leatham, I think, is worth just turning up quickly. And the reason for that is that I just want to deal with my learned friend's comment about Lord Lindley's dicta in that. But just before we get to Lord Lindley, at point 1 of my notes on Quinn and Leatham, I've just extracted some of the other references by the other judges in that case, because the short point on that is that Lord Lindley's comments about interference with dealings essentially reflected the reasoning of the majority, although expressed in different words. So, for example, one sees the Earl of Halsbury commenting that the defendants had wrongfully and maliciously induced customers and servants to cease to deal with the plaintiff, and similar comments by Lord Macnaghten and Lord Shand. So I don't think I need to go to them, but the references are there, and I would perhaps invite your lordships to read them at leisure after the hearing. But if we just want to go to Lord Lindley, because there was a specific point made about what he said, and this is in volume 2, 15. And the relevant extracts that my learned friend took you to are on pages 534 and 535. And Lord Lindley's comments, you'll recall, are the comments that Lord Hoffman relied upon in OBG as setting out the rationale of the tort, and that's the section of the judgment starting about halfway down page 534. So he says, I will now pass to the facts of this case and first consider what the plaintiff's rights were, what the defendant's conduct was, and whether that conduct infringed the plaintiff's rights. And then number 1, he sets out the plaintiff's rights, and that's the extract where he talks about the liberty to deal, and the person's liberty or right to deal with others is nugatory. So that's the section that Lord Hoffman extracts. And my learned friend said, well, that's not the ratio. The ratio is the sentence halfway down 535, where he says the principle which underlies the decision reaches all wrongful acts done intentionally to damage a particular individual and actually damaging him. One might think that if you didn't read that sentence in context, but what you need to do is read the previous sentence where he says the principle involved in it cannot be confined to inducements to break contracts of service, nor indeed to inducements to break any contracts. And then he makes this point, it reaches all wrongful acts. So what he's just saying is that the principle that he's just outlined on the previous page and at the top of that page isn't confined to contractual breaches. That's all he's saying. there.
It's the previous sentence, if the above reasoning is correct, it's
Yes.
sort of reading in his earlier
Yes,
passage.
exactly. So all
You're saying that, yeah.
I am saying that. Yes. So all he is doing is he is making a comment on the ambit of the principle that he's just set out. If he was intending to set out a broader ratio, that would be surprising, because not only is not reflected in the comments of the other judges, but also it's not reflected in his own subsequent comments. And I've put two other references on the handout in under point 1. One is at page 537 at the top of the page. Well, starts at the bottom of page 536. Whether such conduct infringed the plaintiff's rights so as to give him a cause of action. In my opinion, it plainly did. The defendants were dictating to the plaintiff and his customers and servants what they were to do. And then,
I'm sorry, I haven't found that.
at the bottom of page 536, and then the top of page 537.
Well, the remaining question is whether such conduct, is it?
Exactly. And if you read then the next few sentences to the top of page 537, and you see the sentence at the top of page 537, the defendants were violating their duty to the plaintiff and his customers and servants, which was to leave them in the undisturbed enjoyment of their liberty of action as already explained.
Well, that's their liberty of action, which is the plaintiff and his customers.
Yes, but he was talking about their liberty as just explained, and the place that he just explained it was on page 534. When he was talking about the liberty of action of both.
Yes, that's your point. It is the liberty of action of both.
Yes, it's the liberty of action both ways.
The passage at 5367 doesn't make that point.
But it's talking about liberty of action. And the enjoyment of the liberty of action and the breach of that being the conduct that is infringing the plaintiff's rights.
As already explained.
As already explained, exactly. So he starts off by saying this is the right, and then this is the conduct that has infringed that right, using the same language and referring back to his explanation on page 534 implicitly, because the as already explained can only refer to that passage on page 534, which is the passage that is extracted by Lord Hoffman. And there is one other passage where he uses exactly the same language, which is at page 539. And it's about halfway down the page, just above the lower hole punch, the passage that starts, the cardinal point of distinction between such cases and the present is that in them, although damage was intentionally inflicted on the plaintiffs, no one's right was infringed, no wrongful act was committed, while in the present case, the coercion of the plaintiff's customers and servants and of the plaintiff through them was an infringement of their liberty as well as his, and was wrongful both to them and also to him, as I have already endeavoured to show. So 2 times after...
Who is in that sentence?
So the plaintiff, so that he's saying it's infringement of the liberty of the action of the third parties, the customers and servants, as well as the plaintiffs. And so he's made the point earlier on that this is a two-sided liberty. It attaches to both. The plaintiff or claimant has to be free to contract, and the third party must be free to contract with him. So he's talking about a breach of a two-sided freedom of action. So in my submission, that shows quite clearly that the ratio that one derives, at least from Lord Lindley's speech here, is as correctly extracted by Lord Hoffman, that he hadn't got it wrong, and there's not some broader principle that was being articulated here.
And there is the point, isn't there, that in these cases where many judgments are given, later judgments of authority sometimes do say which is the judgment to be given precedence over the others, in the sense of effectively saying the ratio of the case. I think particularly, for example, Boys and Chaplin in our day, where there were 5, if not more, judgments, all saying slightly different things. And then later it was said, well, it's Lord Wilberforce who is really the authoritative judgment where the ratio is. And you can say that likewise Lord Hoffman has selected Lord Lindley as being effectively the ratio of Quinn and Leatham, which is
Yes.
a very, very difficult case to find the ratio of.
Yes, well, that's right. But I would add this, that as I've said, actually what Lord Lindley was saying is broadly consistent with what the other judges were also saying, though in different language.
Yes.
So that was all I wanted to say about Quinn and Leatham. Chronologically, the next case is National Phonograph. I don't think we need to go to this. The point that was made by my learned friend was that this was not an interference in dealing case. And the answer to that is yes, it was. It was described as that in the head note. It was described as that in the...
I don't think the head note can guide us.
It's a summary, but then the head note correctly describes what the judgments go on to say. The point is made in all of the judgments. The interference was with the relationship between the factors and the plaintiff, because there was a contractual agreement. The factors wouldn't sell to certain blacklisted companies, which included, or certain blacklisted individuals, which included the defendants. So what all of them were saying was that the inducement was to break the agreement effectively with the plaintiffs. But in any event, as I said yesterday, that case was not cited by Lord Hoffman in the section of his speech which dealt with the interference with dealings requirement. He specifically cited it for the actionability requirement together with the Longmore case. GWK, that's chronologically the next case, and I've already dealt with that yesterday, where I showed you the passages in that which were relevant, and that's described by Lord Hoffman also as an interference with dealings case. You remember that's the tyre switching case. Barrett's and Baird I said I would come back to, so I'll do that now. That's in Authorities Bundle 1. And my Lord Justice Longmore was asking me yesterday whether I accepted that Mr. Justice Henry's description of the nature of the tort didn't include the interference with dealing requirement, and I said I did accept that. But the reason, well, there are several reasons for this. Firstly, I think it needs to be noted that this was an extempore judgment. And as the relevant passage in that makes clear, and that's Authorities 1, tab 3, and paragraph 28, and that's where he sets out his description of the tort. And it's notable that he says the basic ingredients of the tort are common ground. And he also says that the criterion that there should be an interference with the plaintiff's trade or business, he says there clearly is such interference here. And then he goes on to talk about the other criteria, which he then describes as being an issue in the case. So what appears to have happened is this. Firstly, as he says, the basic elements of the tort were common ground, so there doesn't seem to have been an argument about this. And secondly, there does not...
Don't go too fast.
Pardon me?
Don't go too fast. Right, common ground, and yes, next point.
And secondly, there also specifically doesn't seem to have been an argument about the interference with trade or business requirement, because he doesn't record that as being in issue in this paragraph 28. He just says there clearly is such interference here.
Yes.
And as he then goes on to describe the dispute related to the other issues, the unlawful means issue and the intention issue. So as I've set out on my handout, in those circumstances...
No, I'm not really sure of the, as I said yesterday, I think when Mr. Crowe was making his submissions, of how much weight we should be placing on a first instance
in any
temporary judgment.
Yes.
Where we should really be extracting the principles from Court of Appeal and
Yes.
Supreme Court or House of Lords.
My Lord, that would be my submission, but I'm answering the question I was asked yesterday. Did I accept that? And I'm now explaining why I think he didn't.
Well, as my Lord says, it's probably an irrelevant
Yes.
question.
I didn't say it. I didn't say it was an irrelevant question.
My Lord, I'm very happy to move on from that case. So that was the last.
First instance of not Mr. Justice Henry's stuff was always pretty helpful, if I I say so, respectfully.
Well, that's really the short point. And as I said yesterday, I think it was cited by Lord Hoffman for a different point on the intention requirement, which was disputed in that case. So that was one point that was developed in more detail. But in any event, this is my fourth point on my note, there was clearly an interference with dealings between the third party and the claimant, as in the MLC, which was the employer of the fat stock officers, and provided those officers to work at the abattoirs, and that was the point I made yesterday. And as the judgment explains, without those fat stock officers at the abattoirs, nothing could really happen. They were employed to work at the claimant's abattoirs.
So your third point was what?
Oh, so my points are set out on my note. One, it's an extempore judgment, and so on. Secondly, it's not surprising that in these circumstances that there wasn't a developed discussion. Third point is that it was cited only for the intention requirement. And the fourth is that in any event, there was clearly an interference with dealings. That's, I think, the last of the older cases that my learned friend relied upon. I don't need to take you to the articles. You've seen what's said in those. The only relevant point for today's purposes is that both articles accept that the reference to interference with freedom to deal was part of the ratio. So there was neither of them dispute that. As to the academic discussion as to whether that was right or not, that's really for another place. So then the last page of my note touches on the policy points. Now, as I foreshadowed yesterday, because the claimant seemed to have abandoned the public authority distinction and the distinction between dealings cases and other cases, I don't think I need to develop arguments as to whether a public authority distinction is a relevant one or not. I think what I need to do is address the case that they are now making, which seems to be that the ratio is simply as set out in paragraph 47A of OBG for all parties without any distinction according to who the third party is. And as to that, the basic point is that there is no policy rationale advanced by the claimants for that test. There is no explanation as to why this test should be preferred over Lord Hoffman's articulated test in paragraph 51, which he described as being defined in that way for particular reasons.
Well, do we get any help on the policy issue from the Canadian case?
Well, no.
They took a policy, they as a matter of policy, said we're not going to follow that particular element of paragraph 51 of Lord Hoffman's speech.
The Canadian case dispensed with the requirement altogether. It didn't adopt paragraph 47A. It simply dispensed with that requirement. Having said that that was the relevant requirement, it said we're not going to follow that, but we are going to interpose a narrower intention requirement. So that's just a different way of dealing with it, which the claimants don't suggest. They are simply saying that the ratio is not in 51. There is some kind of third party point, but it's as described more broadly in 47. And my response to that is there isn't any articulated reason why that's better. And in particular, first of all, that's not a test that one sees in any of the older cases, which, as I've said, insofar as a rationale is articulated, it's the one in Quinn and Leatham. But in any event, whether or not that's articulated in any of the older cases, what the simply looking at paragraph 47A in isolation fails to do is to deal with the problem of remoteness.
So who doesn't deal with the problem of remoteness?
Paragraph 47A. If you just look at that in isolation and don't unpack what is meant by an interference with the actions of the third party, as Lord Hoffman unpacks it and says the interference is this kind of interference. And that, for him, explains the problem of remoteness. So by saying it's an interference with the dealings of the third party and the claimant, that's his answer to the remoteness problem.
I don't quite understand what you mean by the remoteness problem. That's probably my fault.
Yes, the remoteness problem is that if you simply say that the tort of unlawful interference is available in any case where the defendant does something to the third party, interferes with the third party's actions in a way that is intended in a broad sense to harm the claimant, then you open the door to a whole panoply of cases. And indeed,
It's a floodgates argument.
it's a floodgates argument, exactly. And Lord Hoffman, as you've seen, was quite concerned that the doors of the tort shouldn't be flung open in that way. And that's why one of the reasons some of the reasons he explains in his article, but he also gives them in the judgment in the passages I showed you yesterday.
Aside from his article, that is the reason why, when he discusses Mr. Sale's and Mr. Stillett's article,
Yes.
he doesn't agree with it.
That's
part
yes.
of his judgment, which
Yes.
is much more important than what he writes in it.
Yes, well, exactly. As I said, the passage in his article beginning, I think, passage in his judgment beginning at around, I think, paragraph 56, where he explains the rationale for the way that he's defined the tort. That's paragraph 56 to 60, and that's where he says, can a stricter concept of intention, as proposed by Mr. Sales and Mr. Stillett's, solve this problem? And he said no.
Which paragraph was that?
It's paragraphs, in OBG, it's in paragraphs 56 to 60, where he talks about the limits of the tort.
Paragraph 59, really.
59 is where he introduces the Stales and Stillett's article, and 60 is where he responds to it.
I mean, it's a curious description in my mind to describe this as a remoteness issue. It's really a width issue. How wide is the ambit of the wrong that will result in this tort being applied?
Yes,
I mean, we normally use remoteness in terms of foreseeability and all that sort of stuff, and
Yes.
proximity.
Well, the reason why I use the word remoteness is a point that I made yesterday, which is that when you define the tort as attaching or engaged when you have a dealing between the claimant and the third party which is affected, that is really a remoteness point, because you're saying the third party isn't somebody who simply suffered consequential loss. It's somebody who is directly impacted because their transaction with the third party, the claimant's transaction, is directly affected by what you're doing. Sorry, the claimant isn't consequential.
Sorry, this is a slightly ignorant point, but is this expression remoteness to describe the point you're now elaborating on one that is in current common usage, or is it your expression?
I think it may be my expression, and I would equally accept width if one is talking about it in that sense of how many consequential claimants can be brought into the tort. Because if you don't have something that limits the ambit of the tort, you do have a situation where lots of people who have suffered loss which is several stages removed from the action that is claimed of can claim. And that is exactly the position here, because we're not even talking about the generics who didn't enter the market because of the patent court judgments or the EPO decision. We're talking about somebody who is said to have been harmed as a result of the actions of the generics not to enter the market. And
we know what we're talking about. You've described it as limiting the ambit of the tort.
Yes, that could
whatever expression you use
exactly
to describe that.
limiting the ambit of the tort is a.
Do you say that the wide-ranging definition that Mr. Crowe would have as a doc would catch, for example, the pizza delivery company that one of their lordships mentions in one of the cases?
Well, I
think it's Lord Walker.
I'm not sure if it would catch that situation, but it would certainly catch a range of situations in which, perhaps by misrepresentation or otherwise, a third party, whether a public or a private third party, is induced to do something, which then has a series of consequential effects on a number of other people who then, under his definition, could claim, because under his definition all that is required is an interference with the third party's actions, and then for the claimant to have suffered some economic harm as a result of that. So whether that's described as a remoteness problem or an ambit of the tort or a width problem. It's the same issue, and it's the issue that Lord Hoffman was in our submission grappling with in this passage of his judgment, and which he answers by saying this problem is solved by this particular construction of the tort. It's not, in his view, solved by the intention point. And that's the issue that in our submission my learned friend hasn't dealt with through his reliance on paragraph 47A. And it's why in our submission Lord Hoffman cannot be taken to have meant 47A in isolation without the explanation as to what that means. So the last point in terms of policy considerations, and it's point 5 on my note, is that if the tort were to be defined in the way contended for by the claimants, that would also, at least in some cases, contradict Willis and Joyce, and that this is the point that we've made in our skeleton argument, which was the Supreme Court judgment which set out the right to claim damages for the tort of malicious prosecution in civil proceedings. And your lordships may recall that was a 5-4 majority in the Supreme Court. And the dissentients were very concerned about extending the tort of malicious prosecution in general terms to civil proceedings. The majority found that the tort could be so extended, but only on very specific conditions which were set out in the speech of Lord Toulson, with whom the others of the majority agreed. And that's all. I don't think I need to go to that because it's set out in our skeleton argument. And that the short point is this, that if the tort in this case were extended in the way that the claimants suggest, then that would effectively supersede the conditions set out in Willis and Joyce, because one could claim for fraudulent representations to the court under this tort, the tort of interference or unlawful means, and one wouldn't need to fall back on malicious prosecution, and therefore the safeguards that are set out in the definition of that tort would fall away. So, my lords, unless you've got any questions, I just come to the last point, and it's really a for completeness point. Yesterday there was some suggestion that the appeal should be allowed on the ground that even if the ratio of OBG was uncertain, then your lordship shouldn't decide it, but should rather find that the relevant part of the claimant's claim should not be struck out. And there are various answers to that. One is the point made yesterday that by the Master of the Roll, that in any event this is a point of law. There's not said to be any facts that are made to be decided that go to this, so the court should simply get on and decide it. But in any event, I think that I need to draw to your attention that this alternative point was raised in the application for permission to appeal before Mr. Justice Roth, and was rejected by him. So it was said that one shouldn't decide the strikeout application if the ratio was uncertain, and he said, and he rejected that point, and that was then not pursued in the claimant's grounds of appeal. So it was advanced as a discrete separate point in their initial application to permission, and then was not pursued on appeal to this court. So insofar as it's of any interest, it's not a point that's open to them in any event. So that just deals for completeness with the certainty point, and I've put the references on the last page of my handout. So then in conclusion, as I foreshadowed at the start, we say that the start and end of the matter in this court should be the OBG judgment, and if your lordships agree with our construction of that, then it's not really necessary to look behind that to see if Lord Hoffman's articulation of the tort was consistent with the earlier case law. It was uncertain, and it has now been clarified and set out in OBG. For good measure, though, and because the earlier cases were referred to, I've shown your lordships those earlier cases, and in our submission, Lord Hoffman's ratio was indeed entirely consistent with those earlier cases, including Lonro for the reasons that I gave yesterday. And as I've explained today, it was and remains based on sound policy considerations. And in our submission, there is and should be no uncertainty as to that ratio. And we respectfully submit that if the claimants disagree with that, then that's a matter for another court if this case ever gets there.
So your final position then is that your clients can be as fraudulent as they like. They can deceive as many patent offices and courts around the world, and that, unless they are in a dominant position and have competition remedies, the British taxpayer has no remedy as a result of this fraudulence.
Well, my lord, that's something of a jury point. I didn't
It is,
go.
of course,
I didn't go into.
But do you accept that?
So I think the answer to that would be there is a specific statutory framework set up in relation to competition law, which the claimants have relied upon. There are also other distinct torts, but if they don't fall within those, then this court should not extend the boundaries of the tort
I quite see
beyond
that.
that.
We have to accept, if we do, that there is no remedy for the British taxpayer for these excessive drug prices.
The answer is that if there is no competition concern,
Yes.
and if they can't bring themselves within other torts, such as malicious prosecution, then the boundaries of the common law have been circumscribed by OBG. And simply making statements and submissions, and we don't in any event accept that they were false.
No, of course not.
But making
Your
submissions...
own application
Yes.
invites us to assume the worst.
One has to proceed
Yes.
on that basis. So by making, so the short answer is by making submissions to the patent office that turn out to be unfounded does not give claimants.
That's
the
not my
direct
point. You
position
can be
that
as fraudulent
those
as you like,
claimants-
is my point. Just making submissions turn out to be wrong is not the point. You can be as fraudulent as you like, and there is no remedy in the absence of a dominant position.
Well, not in the absence of a dominant position, because of course the competition claims rest not only on dominance, but also agreements. And at the moment, some of the agreements claims have been upheld by the General Court. So our submission is the remedy lies in competition law, and that was essentially what Mr. Justice...
The agreements you're talking about, what are cartel arrangements?
Well, I think cartel's probably the wrong word. They were patent settlement agreements, which were found to have been an infringement of Article 101. Most of them, one of the Article 101 infringements was set aside by the General Court. But the answer is that submissions to a court that turn out to have been wrong have never been.
No, that's not the point my lord's making. But I think you have to face up to the point that's being put to you, which is unless you fall within a breach of competition law, or you can't, and you can't bring yourself within malicious prosecution.
Yes, there is no.
As the law now stands, as binding on this court, is your case, as binding on this court, the Court of Appeal in OBG.
There's no remedy because it's not unlawful, and that was the point that Mr. Justice Jacob made in the Apotex case.
Not unlawful to lie to the patent office seems to me to be a very strange
Well,
submission.
there's a different question about the fraud on the patent
I know
office.
the facts are all contested, I understand that,
Yes.
but my lord's point is, I suggest, a fair one.
Yes. There are lots of other issues in the case. Ultimately, the answer is that there is in our submission not this remedy.
Yes, we understand.
Thank you very much, and congratulations on finishing, I think, just about within the half hour.
My fault. It was more ultra
Yes, you would have done, but for my lord's question. Thank you. Yes, Mr. Craig.
Could I just answer one question that I was unable to answer yesterday, and that was the point of detail as to which defendant is the target, so to speak, of the tort claim. My Lord Justice McCombe said he'd read that it was only the third defendant. That is correct. I've been reminded, if one just don't know if you want the paragraph numbers, but if one looks at paras 37 to 38 and 73 to 78 of the particulars of claim, you'll see that although in fact if one looks at the prayer, the claim is simply for damages indiscriminately, but if one actually looks at the pleading in those paragraphs, you'll see that it's the third defendant that had exclusive conduct of the application to the EPO for the 947 patent.
That's the reason.
And
Yep,
as well as the defence of the opposition proceedings in the EPO. So that is the correct position. I'm grateful. Just a few points of significance that we wanted to deal with. The first arises in this way. My learned friend said yesterday that my fallback argument is that what was said in para 51, second sentence, is obiter. And that is not what our skeleton says, and it's certainly not what I intended to convey on my feet. Can I just, for the avoidance of doubt, enumerate the three ways in which we have advanced your possible approach to 51, second sentence? Our first argument has been that, properly understood, second sentence of para 51 is simply a description of why the test under 47A happens not to be satisfied in some or possibly all dealing cases, and in particular why the claim fails on the facts of Douglas and Hello. Now, approaching it on that basis, we are saying 51A adds nothing of legal content to the description of the tort. It is a description of, or to the definition of the tort. It is a description of why the 47A test isn't satisfied in some cases. So that's the first analysis we offer to you for acceptance or rejection. The alternative argument is to accept that the second sentence of para 51 was intended by the House of Lords to be a freestanding substantive requirement additional to 47A, but only such a requirement in some or possibly all dealing cases. And in that context, we would say the House of Lords was not expressing a view because it didn't need to. It was not expressing a view as to whether the same element, even if it is a necessary element in dealing cases, the Lords were not expressing a view as to whether the same element is required in all cases of loss, causing loss by unlawful means. And the third alternative, or third option, is that if you reject that analysis of what the words on the page mean in OBG and Allen, and if you accept the suggestion that the words on the page in the second sentence of para 51 were intended by the Lords to be an expression of the necessary elements of the tort in all cases of causing loss by unlawful means, whatever the facts might be, then with the greatest respect to the House of Lords, that is not part of the binding precedent value of the case. It's not a question of what is or isn't the ratio, so to speak, it is what is the binding precedent value of the case. That is why we took you in our skeleton and orally to Quinn and Leatham and frozen value, because they both make clear what in a sense is blindly obvious, but one sometimes forgets when one is worshipping at the altar of Lord Hoffman, that the House of Lords isn't a legislator. That's what I meant when I said yesterday, it's not the Law Commission, it's not Parliament. It's not codifying the tort. It is making a decision, and that's simply not how the common law works. What Quinn and Leatham and Frozen tell you is that the common law, as it's sometimes said, scores singles, doesn't hit sixes. It decides the case in hand, and the proposition of law is precedent in relation to the circumstances of that case. And that is why I emphasise to you that OBG and Allen is not a public authority case. It is simply deciding the law in relation to the facts of that case. The second thing I just wanted to cover briefly was this. My learned friend spent some time going through the historic cases in order to try building up a suggestion that the second sentence of para 51 does have some historic antecedents. And you'll recall that she went to various, but can I just, you may actually have them on the list. She went to the references in OBG to Tarleton and McGawley, Quinn and Leatham, Dunlop, Johnson and Deakin. And she latches on the word liberty that occasionally crops up in those discussions. We submit that those passages, when you have an opportunity to read them without the scrum of litigation around you, when you read those passages in calm isolation, they provide support for 47A, not for the second sentence of 51. What we say, what I was attempting to show when we took you through the earlier case law, is that as the tort was finding its feet, the courts were really grappling with three issues. The first was, does there have to be a legal right in the third party which the defendant has infringed, which my learned friend calls the actionability point? The second question that the decisions were grappling with was, does there have to be a legal right in the plaintiff that is infringed? And you will recall that it is in that context that the earlier cases were discussing the question whether a plaintiff's liberty to carry on his trade, the shipwrights, whether the liberty to carry on their trade, the liberty to do business, was a right that the law protected. As it happens, where the tort has now come out, the answer to that is no. The tort is committed in relation to acts by a defendant which are unlawful as against the third party and are then actionable by the plaintiff, even though there isn't a tort, there isn't a separate tort, so to speak, committed an unlawful act as against the plaintiff. And that's the difference between the Lumley and Guy inducing breach of contract, where there is a breach of a contractual right vested in the plaintiff, and the tort of causing loss by unlawful means, where the unlawfulness is as against the third party, not an unlawful act per se against the plaintiff. It is in that context that you will see references in the earlier case law to the question of interfering with liberty. But it is not a defining element of the tort. The third question that the courts grapple
that liberty
is what the
not a
context.
defining element of the tort.
It is because, yes, exactly, that is what we say. And just to add a gloss to that, because a very large number of these cases, indeed, other than this case, the NHS Luton case and Lunra and Fired, almost all cases happen to be cases involving trading disputes. So yes, the court is going to be thinking about and describing by reference to facts which do involve interfering with trading relations. But that is simply a description of the most common factual situation in which the concept of this tort happens to arise. There is nothing in the earlier case law to justify a decision of principle that the tort can only be committed in certain factual situations. And that is actually what the defendant's argument in this case is. Their argument is it's not a principled tort based on legal elements, but it's a factual tort that can only be committed in a finite number of factual circumstances.
Right, I'm sorry to interrupt you, Mr. Crowe. Problems again with the equipment.
Oh dear.
What do you want to do?
Can I just carry on and hope
as
that
I
my
said,
words
you
are
asked for the-
preserved in your mind and your notes?
We don't mind. It's just that your side asked for it. You're happy to carry on.
I am. I checked yesterday if this happened again. We're happy to trust your lordship's pens and memory.
You might be a bit sort of gentle.
Ease up.
I, for one, have a rather bad writing wrist at the moment. So.
I'm just trying to grasp this second point. So I understand, if I put it in my own language, you're saying what they're seeking to find in these older cases is is aside from this tort, whatever it is there some separate legal right, legal cause of action in the claimant as between the claimant and the defendant? I think that's what you're saying.
Not quite. Sorry. Just stepping back, the difference between our analysis and my learned friend's analysis is that we embrace 47 of OBG as the definition of the tort. The tort requires, as a matter of principle, an act done by the defendant which is actionable by the third party and which interferes with the actions of the third party in which the claimant has an economic interest. We embrace that definition. My learned friend wishes to add a further requirement that the interference with the actions of the third party must be actions involving the freedom of the third party to trade, to deal with the plaintiff. So the argument that's being run is that the principled description of the tort in para 47 is, by reference to the second sentence of para 51, limited to a finite category of factual situations in which the interference takes the form of an interference with the third party's freedom to deal with the plaintiff. That is the difference between us, and we say that it is entirely unprincipled to define a tort by reference to a finite factual set of circumstances. The tort is defined by reference to the principled approach in 47. And if you look at the earlier case law, yes, of course you can find descriptions and discussion of factual circumstances in which a third party's liberty to deal with the plaintiff has been interfered with. But that is simply a factual description of the circumstances in those cases in which the tort happens to have been committed. They are not definitions of the principled elements that are required to be proven in all cases for the tort to be committed. And that's why when I took you to Quinn and Leatham and showed you that paragraph that my learned friend is fond of and Lord Hoffman quoted, talking about the rationale of the tort, in context, if you read the whole of that paragraph, it is quite apparent that what his lordship is there doing, again, is simply describing the rights which it was said in that case were being interfered with. So our submission to you is that if you have the opportunity to go back through that earlier case law in order to see whether the second sentence of para 51 does or does not found itself as a matter of legal principle in the earlier case law, the answer is absolutely not. And that is why we do urge you to accept that that second sentence if it is being offered by the other side as a necessary principal element in the tort in all cases, comes from nowhere in terms of legal principle, and it is unjustified in terms of policy. And just dealing with the policy point,
You're still on your point too.
I am drifting off point 2 onto the very last point my learned friend dealt with, which is policy.
You say that the court's grappling with 3 issues.
Yes.
You said what the first and second one is.
I'm sorry,
You're
did I
going to know what the third
Okay.
is.
The third one was essentially causation.
Ah, yes.
Was the defendant's action as against the third party the cause of the loss to the plaintiff? And essentially it's in relation to the element of causation and its interaction with the right of the third party that's being interfered with, that the RCA and Pollard cases are decided, and on the basis of which OBG and Allen was decided, because it was said that the interference with the third party's actions in those cases were not causative of the loss to the plaintiff, because as we were discussing yesterday, the licence granted by the Elvis estate was a matter of history, and there was no interference with its ability to do to grant that licence and continue it. So, my lords, that is essentially my second point, that the historic case law does not lead to 51(2) as a matter of principle. The significance we invite you to draw from that is that Lord Hoffman cannot have intended 51 second sentence to be a statement of principle, because it is not supported by previous authority. On analysis, it isn't principled, it is simply a factual circumstance in which 47A may not be satisfied. And I was going to go on and say it would be unprincipled to embrace it as a necessary element in all torts for policy reasons. And the policy reason essentially is the rhetorical, well, not entirely rhetorical question my Lord Justice Longmore put to my learned friend late on. Why on earth, this is the very first question I asked your lordships to consider, why should the common law evolve in a way which deprives the public purse in this case an opportunity to make a recovery against what by definition is a fraudulent defendant? Why should it choose not to make that remedy available? Simply because the tort has previously, most often, been committed in relation to trading cases. And our submission, there is absolutely no satisfactory answer to that. And my learned friends made a couple of references just in sort of roughly in the context of policy. She referred to the availability of some competition law statutory remedies. Well, that isn't a general answer to the point as to what is the general scope of this tort. This tort doesn't arise or not arise in competition cases. Lunro was not a competition law case.
Well, at some stage, I'd like you, if you would, in this reply, to say what you have to say about Ms. Bacon's comments about Lonro and Fire.
Absolutely.
Please.
I'll just go back to that
in your own time.
Yeah. And secondly, Malone Friend said that there would be some sort of clash with Willers and Joyce and malicious prosecution. But the fact is that the Secretary of State could not recover for the public purse in respect of malicious prosecution, because the Secretary of State was never a defendant in any relevant proceedings. So the fact that a tort may exist for one party's benefit in relation to one set of facts, and a different tort may be available to the defendant in those proceedings, should not trouble you. Again, Lord Halsbury's comment in Quinn and Leatham right at the beginning, the law is pragmatic, the common law is pragmatic, it develops remedies in order to meet the justice of cases. The fact that the Secretary of State may be allowed to bring this claim should not cause you any concern, simply because the test that may be applied in relation to a claim by the Secretary of State may well be different from the test that would be applied if he had been a defendant in enforcement proceedings in the court and was seeking to bring an entirely different tort claim based on malicious prosecution. Why not? And in a sense, exactly the same.
Just pause there. So, I mean, you do accept that in a case where, not a public institution case, but in a case where there is an overlap between the two on the facts,
Yes.
then the safeguards on limitations for malicious prosecution would be pushed away if you're correct in saying that the principle of this tort is that set out in
Yes,
paragraph.
that is perfectly possible, yes. But by no means every case, even in relation to a generic manufacturer.
Why isn't that just as unsatisfactory? I mean, however you look at it, there's an unsatisfactory end in certain factual situations.
Well, to some extent, yes. Possibly. But if one is just thinking about the kind of factual situation with which we are dealing, if there is a generic manufacturer who thinks, well, I'd quite like to be in this market, they've got a patent. There's no point. I'm not going to incur all the R&D costs, launch the product, get sued, and then sue for malicious prosecution. I'm simply not going to enter the market, and if it turns out that the patent is set aside, I will then sue for causing loss by unlawful means. Factually, there is, yes, one case, the Appellants case, where there was litigation in order to protect this. But what you shouldn't define the scope of the tort of causing loss by unlawful means by reference to whether it is or isn't likely that competitive generic manufacturers will or won't take the risk of entering the market and being sued and then being able to sue for malicious prosecution afterwards. I mean, one's simply got to proceed on the basis of a principled approach to what the tort contains. And the other point that is important, my learned friend was very keen to talk about safeguards and floodgates. Well, there are two or three answers to those concerns. One is, our approach doesn't open any floodgates at all, because the control mechanisms are found in paragraph 47A and B. There has to be unlawfulness as against the third party, and there has to be an intention to injure the particular plaintiff. Those are the relevant control mechanisms that keep the floodgates closed. But one should not only be thinking about, well, how can we limit this tort as narrowly as possible? That's not the object of the law. The law is not there simply to constrict remedies against fraudsters. The other side of the question, depending on floodgates is the word defendants use, fairness is usually the word plaintiffs use. Why shouldn't justice, the common law, make available a remedy to the Secretary of State in this kind of situation?
Well,
when there are sufficient control mechanisms in place?
That may be a question to be put to the Supreme Court.
Well, these are questions that I'm asking you to ask yourselves when you're looking at that second sentence and trying to decide whether Lord Hoffman really did mean that was an unavoidably necessary element in the tort in all circumstances. If you're against me on that, I lose. I accept that. But I'm trying to do what I can to get you in the frame of mind to accept that isn't what he meant, because he can't have done because of the consequences.
For my own part, I have difficulty in seeing how Lord Hoffman himself got around Lonhro and fired.
Well,
that's what I'm interested
yeah.
in.
Well,
it seems to me unsatisfactory with respect to him.
Well, what we say about Lonhro and fired and what my learned friend's answer to it is. Actually, can I just come to that in a moment and just deal with a couple of other things first? Yeah, just finally on policy, I think you probably already got this point. Before I leave the question of policy, floodgates and control mechanisms and so on. As I say, we say that there is no policy reason for excluding the claim in this case. As I said, the control mechanisms are those in paragraph 47. My learned friend said, I mean, not this particularly matters, but just for the sake of completeness, my learned friend suggested, I think, this morning that the Canadian case, AI Enterprises, actually abandons paragraph 47 of Lord Hoffman. It doesn't. All it does is disavow the second sentence of 51. It embraces, as we saw from the summary at the very beginning in paragraph 5 of the judgment, it embraces the two control mechanisms in para 47, which is that the wrong against the third party must be actionable, and the wrongdoing by the defendant must have intended harm to the plaintiff. So we do ask you to look again at AI Enterprise, because we do think it embraces a logical rationale for the tort. I just wanted then, thirdly, to spend, or possibly fourthly, to spend a few moments on my learned friend's analysis of OBG and Allen. And it will just be necessary to get this one case open briefly at page 31. Now, we've seen para 47. What if we then, just turn over to page 32. What my learned friend says is it's important, she says, in understanding what is being approved and what is not being approved, to understand the structure of Lord Hoffman's speech. And she says it's dealing with three things. In turn, she says it's dealing first with actionability, which she says is paragraphs 48 to 50. And then she says it's dealing with the nature of the interference, which she says is 51 to 61, which is where she says the 51 second sentence is intended to sit. And thirdly, she says it's dealing with intention, which starts at 62 through to 64. Now, it is by salami slicing it in that way that she tries to give prominence to para 51 as a self-standing, so to speak, requirement. And in our submission, very shortly, that is simply not a correct analysis of the structure of the speech of Lord Hoffman. Paragraph 47, and he's, with the greatest respect, he's not a careless writer. Paragraph 47 says that the essence of the tort is A, wrongful interference with the actions of a third party in which the claimant has an economic interest, and B, an intention thereby to cause loss. There are two elements. They are lettered, A and B, in paragraph 47. My learned friend's analysis only works if Lord Hoffman has wrongly subdivided his own analysis and missed out A1, A2. And it's perfectly obvious he hasn't. And that's not just a sort of structural comment on how many subparagraphs there are in paragraph 47. It is a comment on the discussion that then follows from 48 to 60. The whole of 48 to 60 is 47A. It's just talking about wrongful interference with the actions of a third party in which the claimant has an economic interest. It's the interest in the actions of the third party. And one sees that simply if one goes to page 35 and one sees how he concludes the first half of the discussion. He says in 61, I would only add one footnote to this discussion of unlawful means. This discussion is the whole of 48 to 61, which is an exegesis on 47A. 47A is wrongful means. That is what 61 says, I'm now wrapping up. And then in 62, he says, finally, there's the question of intention, which is 47b. So if you want the structure, 47 has 2 subparagraphs, it has 2 concepts, it doesn't have 3, it doesn't have this third bolt-on of a freestanding requirement in the second sentence of paragraph 51. So if you're looking, as I say, for a structural approach, that in our submission supports our analysis. Next point, very briefly, the cases that my learned friend looked at briefly today simply don't, in any meaningful way, reflect a situation in which there has been an interference with the third party's freedom to deal with the claimant. If one looks at Barrett and Baird, National Phonograph, GWK, it is stretching beyond reasonableness the concept of interfering with a freedom to deal with the claimant to try and box those cases into the straitjacket of the second sentence of para 51. I'm not going to expand on that. Your Lordships will look at the facts again, and your Lordships will take the view as to whether or not swapping tyres behind people's backs really does fit within that, or whether it fits properly, as we say, within 47A, a wrongful interference with the actions of a third party in which the claimant has an economic interest. Which leads me finally to Lunro and Fayed. My learned friend says Lunro and Fayed didn't decide that there is no dealing requirement. What it did decide was that there is a requirement for actionability, and that therefore that bit of it is upheld in OBG and Allen, and there was nothing in OBG and Allen there was nothing in Lunro and Fayed for the House of Lords to overrule in OBG and Allen. Well, that, with the greatest respect, simply does not work. If we just look very briefly again at what is said in the Court of Appeal in Lunro and Fayed at page 492 in Justice Rafe Gibson's judgment, so it's bundle 1, tab 9. Page 492, letter C.
So which page?
So 492,
Yes.
letter C. It's contended that the unlawful means used to the Secretary of State must be itself demonstrably actionable as a complete cause, and that in this case that is not pleaded as an alleged fact, because it's not said that there was any financial loss suffered by the Secretary of State. For my part, I do not accept that fraudulent misrepresentations used to a public official in the circumstances alleged in this case to be unlawful means, for the purposes of the tort of unlawful interference with business, because there is no identifiable financial loss caused, in addition to the fact that a public official has been caused to do by the fraud what otherwise he would not have done, or not do what otherwise he would have done. That is the ratio of Lunro and Fayed in relation to actionability. If we look at what Lord Hoffman says about it in OBG at paragraph 50, he's talked about National Phonograph, and he says Lunro is arguably within the same principle. The plaintiff said that the defendant had intentionally caused it loss by making fraudulent statements to the directors of the company which owned Harrods and to the Secretary of State for Trade and Industry, which induced the directors to accept his bid from Harrods and the Secretary of State not to refer the bid to the Monopolies Commission. The defendant was thereby able to gain control of Harrods to the detriment of the plaintiff. and he says Lord Dillon referred to National Phonograph as authority for rejecting the argument that the means used to cause loss to the plaintiff could not be unlawful because neither the directors nor the Secretary of State had suffered loss. This seems to me correct. Now, it is perfectly true that His Lordship is there dealing in terms with the question of actionability in that case. But could I just, perhaps to save your pens, invite your attention to what we say in our skeleton on this point, because I don't think I can improve on it on my feet. Our skeleton is in the core bundle, tab 2. And if we go in tab 2 to bundle page 25, internal page 15.
Internal page 15.
15.
Yeah.
Paragraph 26, we mentioned that the submission my learned friend made was accepted by the judge below. On this point, the judge attempted to deal with Lunro and Fide by observing correctly that Lunro and Fide was concerned and was cited by Lord Hoffman as concerned with the actionability of unlawful means at the instance of the third party, not with the existence or absence of a dealing requirement, and the earlier case was decided when the limits of the unlawful means tort were yet to be defined. However, none of that squarely faces the real problem for the judge's reading of OBG posed by Lunro and Fide and the terms in which it is discussed in OBG. First, it is implausible that Lord Hoffman would cite Lunro and Fide, explain the basis on which the unlawful means tort was advanced in that case, incorporate the decision into his lordship's exposition of the historic case law, but fail to mention, if it was the case, that he considered the case there advanced to be inconsistent with the fundamental principles of the tort he was expounding. Secondly, as explained in para 12.4.5 above, Lord Hoffman in fact indicates in para 56 that he regarded Lunro and Fide as within the founding principles of the tort. And just pausing there, your Lordship may remember I read that passage to you yesterday. That was where Lord Hoffman wraps up that section of his speech by saying that none of the authorities cited to the House of Lords in OBG appeared to expand the tort beyond the confines identified in Allen and Flood and Quinn and Leatham. And that's the paragraph 56 reference. Lunro and Fide was one of the cases plainly cited to the House of Lords, so Lord Hoffman, we are entitled to say, Lord Hoffman indicates that he regarded Lunro and Fide as within the founding principles of the tort. So our submission is that whilst technically, OBG didn't have to overrule Lunro and Fide, because Lunro and Fide doesn't actually say there is no dealing requirement. OBG wouldn't have to overrule Lunro and Fide for my learned friend to be right, but it would, with the greatest respect, be quite incomprehensible if Lord Hoffman was saying that the result in Lunro and Fide was wrong without mentioning it. Having cited the case, as we say, described the basis upon which the tort was sought to be upheld in that case, and then said nothing by way of doubting it. So that, again, in our submission, is a very powerful indicator, coming as it does in the very paragraph before the one in which this critical sentence in para 51 actually appears. If the two were inconsistent with each other, Lord Hoffman would have tried to reconcile them. He doesn't. And so in our submission, the short answer does come back to the point that we opened with, which is that a strikeout of a public authority type case, a non-dealing case, survived to the House of Lords in Lunro and Fide, unless you come to the view that OBG and Allen certainly does effectively overrule the outcome in that case, we ought to survive in this court.
How do you deal with the point about it's not in the grounds of the appeal and it was abandoned in the application of permission to appeal, this point about if there's sufficient uncertainty, we should allow it to go ahead?
I'm not sure, with the greatest respect, I'm not sure this is a separate ground of appeal. The argument is we are right as to what OBG and Allen does say, you either accept that, in which case we win, or you positively reject it, in which case we don't win, or I suppose there is a middle course, in which case your response is, well, we're not certain, in which case our argument would, and it's not a separate head of appeal, it is simply an argument, we would say, that if that is where your lordship's minds end up, then the right order would be to make, the right order to make would be to allow the appeal. It's not a head of appeal, it is simply an argument as to the appropriate test you should apply in a strikeout case.
So it can all be argued again before Mr. Justice Roth.
Yeah.
Slightly uncommercial way of looking at things, isn't it?
Well, my lord, it's as my learned friend and said earlier, and I accepted yesterday, that this point may not end here. But one has to address the arguments as they currently exist on the facts as they exist, and we do submit it is not a strikeout case. I don't know if there's anything else.
So, but I think we've got to on that point, so we can just at least get some clarity on that, is that you weren't able to explain yesterday, and I don't think you're explaining today, that the outcome of this point will turn upon any questions of fact.
No, I don't think I can, because essentially
so my
the fact assumes
taking
to
my
be
Lord's
proven.
point, if we were, you're completely correct. If we were with you, you'd succeed on your interpretation of OG.
Yeah.
If you were wrong, and we were satisfied that the respondents were right, we dismiss the appeal.
Yeah.
But it doesn't seem to be very pragmatic to say, well, we're uncertain what was meant, therefore it should go back for somebody at first instance to decide the question to come back up again. That doesn't seem to be very sensible.
Lord, that's not the outcome I'm urging you on. All I'm saying is that would be the right order to make if that's where you ended up. As I say, I mean, our argument is that we are right on OBG. Yes, I'm not urging you to reach the conclusion of uncertainty. I'm urging you to reach the conclusion that OBG does say what we say, does not say what my learned friend says. And I do accept that it is a hard-edged question of law, and you assume the facts pleaded will be proven. So it is difficult for me to say that anything that comes out of trial would affect the outcome in relation to that argument. I do accept that, and so it may be for that good reason that those who handled the case before me didn't actually put as a head of appeal that there is uncertainty.
No, but I think that where it ends up really is that you say, well, if we are satisfied that you are correct on your interpretation of the effect of Lonro, then that Lord Hoffman didn't dissent from that, we have to allow the appeal. It's as simple as that.
Yes.
If, on the other hand, we're not satisfied that that was the effect of Lonro, or that Lord Hoffman didn't feel that it precluded him from reaching the decision that the respondent and Miss Justice Roth thought was appropriate, then that's the reality. Then we will dismiss the appeal. I mean, that's really the parameters of it.
My Lord, the commercial pragmatic point put to me by Lord Justice Longmore is no doubt a powerful argument for your lordships not to be uncertain.
Yes. Whatever uncertainty we may feel during the arguments,
yes,
we come down one side or the other, and the discontented party can see that they can go somewhere else to argue it again.
Absolutely, I suppose. And I suppose the answer might be that if you were uncertain in the sense that you did consider that Lonro and Fide is, on its face, supportive of our position, but you are uncertain as to whether or not Lord Hoffman did or didn't overrule it, you would, in that situation, not be bound by what Lord Hoffman said, because if it's not part of the precedent value in the case, you have to decide what the scope of the tort is. It's not a question of unpicking what Lord Hoffman did or didn't say. It's you having to decide what the proper scope of the tort is. I'll leave you with that.
Thank you. Thank you very much, Mr. Crowe. We're extremely grateful to all counsel. No doubt leaders very much assisted by their juniors and by those instructing you for the argument, important and interesting argument on this important and interesting issue. We will reserve our judgments in the usual way when you receive our draft judgment or judgments. Please agree on form of order. Any further submissions to be in writing.
Authorised.